Good morning, everyone. Thank you for joining PHCA for today's webinar, Criminal Liability for Abuse and Neglect, New Law and New Risks. I'm Wendy Johnson with the Pennsylvania Healthcare Association. Before we begin, I have a few housekeeping items to cover. PHCA offers monthly webinars to members to receive updates from department staff on regulations, learn from industry experts on current trends and practices, and to gain a better understanding of practical application tools to equip you so that you may continue to provide the highest level of quality care possible. This webinar is being recorded and will be made available on the PHCA website later today. The webinar has been approved for one continuing education credit for PHCA members. Credits will be uploaded to NAB within the next 2 weeks for those who have provided us with your unique NAB number. I'll be sending a link to a quick survey. Your feedback is important to us and for our speaker, so please take a moment to complete the survey. All attendees will be in listen-only mode. However, throughout the presentation, please feel free to submit your questions using the questions pane on the right hand of your screen, and our presenter will address them at the end of the presentation. Now for today's webinar. In June 2018, Governor Tom Wolf signed House Bill 1124 into law, Act 53 of 2018, expanding the offense of neglect of a care-dependent person and providing for the offense of abuse of a care-dependent person. How will this new law affect your care for your residents? And how will you train your staff? Paula Sanders, Principal and Co-Chair of Post and Schell's Healthcare Practice Group, will walk you through this new law and how it will impact your work. Your learning objectives for today's webinar include discussing the new law that expands criminal neglect and creates the new crime of abuse of a care-dependent person, identifying potential risks and ways to minimize risks to your staff and your center, and lastly, considering increased reporting obligations and survey implications under Ftags 600-F610. I'll now turn the webinar over to Paula.
Thanks so much, Wendy, for that introduction, and good morning, everybody. I'm glad you could join us this morning for the webinar. As Wendy mentioned, we're going to spend a good portion of the next hour talking about Act 53 of 2018. Pennsylvania for years has had a criminal statute that made the neglect of care-dependent persons a crime, but only recently did the legislature finally pass a law that expands the definition of criminal neglect, which we're going to talk about because there are some real significant changes. The law also expands the several definitions, but more importantly, it also created a new crime of criminal abuse of care-dependent persons. And you can see on your screen right now, we're on slide number 2, the statutory reference where it says 18 PS section 2713. That's the Pennsylvania Crimes Code. And these two new crimes appear in section 2713. Wendy mentioned that Governor Wolf signed the bill on June 28th, 2018. It passed unanimously. The Pennsylvania Attorney General's Office and various consumer advocates have been lobbying for a number of years to have this law changed and expanded. And at the very end of this last legislative session, or towards the end of the legislative session, the bill finally passed unanimously. So we're going to be talking about that and then spending the second part of the webinar talking about the requirements of participation and how that's going to intersect with these new laws. So we'll start first with the expansion of a definition of caretaker. To me, one of the most significant expansions is in this area with respect to who can be charged. Remember, we're talking a criminal statute now, and a caretaker has always been someone who's employed by the nursing homes, personal care homes. That's always been part of this focus, right? Where nursing homes, personal care homes were always the main focus. But the law has expanded now. So we're not just looking at nursing homes, personal care homes, assisted living, private care residences, or dom cares. We're looking as well at community residential facilities and ICFs for a person with mental disabilities. And the caretaker can be the owner, the operator, the manager, or employee of these types of facilities. But more importantly, the law's been expanded to include adult day living centers, home health service providers, and this is the real significant one right here, any entity licensed under the Healthcare Facilities Act, and that includes hospitals. And this is the first time that hospitals and their employees can face criminal liability for the care that's provided within their facilities. Also, the law is expanded to include an adult who lives with a care-dependent person and has a legal obligation to provide care, or who has voluntarily assumed such an obligation or has been given that obligation because of a court order or a family relationship. So that's the first part. And for those of you who are listening who do have other entities besides your skilled facilities, particularly, adult daily living centers or home health, you're looking at liability now as well. It's not just focused on your personal care home or ALR or SNF. So that's major change number one, significant expansion of the definition. The piece that the Attorney General's office is so excited about is this next expansion. They no longer need to prove that there has been injury. Criminal neglect is now much easier to prove under the statute. They only need to show that a caregiver intentionally, knowingly, or recklessly endangered the welfare of a care-dependent person. And that reckless endangerment is a significant expansion because they no longer need to prove actual injury. And an example of this could be the conscious disregard of a substantial and unjustifiable risk to the care-dependent person. So, for instance, if you have a repeated failure to follow a plan of treatment, that could be reckless. And that injury does not have to be proven. And let me give you an example of what I think a repeated failure to follow a plan of treatment would be. Care plans for two-person assist that's repeatedly ignored. Med errors would be another. Reckless endangerment, the failure consistently to transcribe medication orders consistently from one month to the next that could create a substantial and unjustifiable risk to the patient or resident. So this reckless endangerment, huge expansion, and one that you should all be thinking about as we go through the rest of this presentation, particularly when we get to the part of talking about the intersection of Act 53 and the regulations and training. Other examples of criminal neglect would include intentionally or knowingly using a physical or chemical restraint or medication, or isolating a care-dependent person that causes bodily injury, serious bodily injury, or death. So what are the penalties for criminal neglect? First-degree misdemeanor for bodily injury is less than or equal to 5 years and or $10,000, less than or equal to $10,000 in fines. First-degree felony if it results in serious bodily injury or death, less than or 20 years in prison and or up to $25,000 in fine. Now notice the first two that we're talking about is bodily injury or serious bodily injury or death. When we talk about reckless endangerment, we don't need to have proven injury. That's the first offense is a second-degree misdemeanor, which could land the individual up to 2 years in jail and or a $5,000 fine. And third-degree felony for a course of conduct of endangerment. That means, repeated endangerment. That's up to 7 years in jail and or $15,000 in fines. And, certainly if you do have questions about this section, shoot Wendy questions. We'll try and answer them at the end of the presentation. And if we don't get to them, we will address them via email following the webinar. So that's criminal neglect. Again, the statute has been here for quite some time. There have been some very recent prosecutions in the criminal neglect side. All of the criminal neglect cases, I should mention, the jurisdiction for prosecuting under these two statutes is vested in the local district attorneys, so they could obviously bring charges. But the main impetus of these investigations is with the Pennsylvania Office of Attorney General. The Medicaid Fraud Control Unit has established what was previously called their Elder Abuse Task Force. I would expect with the changes in these definitions that they're going to be looking not just at elder abuse, but at abuse of all care-dependent persons. So we may see a name change. The new crime of abuse of a care-dependent person was actually taken from a pre-existing statute that dealt with harassment. And that statute was originally created for crimes. I'll give you an example. If you're in a dispute with a neighbor and you keep going to their house at 3 o'clock in the morning, throwing stones at their house or ringing their doorbell, that is the kind of language that the legislature used when they created this new crime of abuse of care-dependent person. And the new crime with respect to care-dependent persons says that the caretaker has to have intent, and the intent has to be to harass, annoy, or alarm a care-dependent person. Examples in the statute would be striking, shoving, kicking, subjecting, attempting to subject, or threatening a care-dependent person with physical contact. I think we would all agree that those actions are abusive. But note, we don't, for purposes of abuse, have to show, if we're the prosecutor, that there's been an injury. I just have to have the intent to harass, annoy, or alarm, or attempt to or threaten a care-dependent person with physical contact. The next element, it would be engaging in a course of conduct or repeatedly committing acts which serve no legitimate purpose. Hard to conceive of how that is going to play out in terms of allegations within the skilled nursing setting. But again, if you consider the genesis of this language, which comes out of Section 2709 of the Crimes Code relating to the statutory charge of harassment, you can see that that might make sense in the context, for instance, as I mentioned before, of neighborhood disputes. Another crime of abuse would be communicating to the care-dependent person any lewd, lascivious, threatening, or obscene words, language, drawings, or caricatures. Now, think back a few years ago when CMS issued their memo on abuse, including in the skilled nursing context, posting pictures of residents on Facebook or otherwise embarrassing them through media. That now is a crime specific under this abuse of care-dependent person, or could be potentially. The next one I find amusing in this context, which is communicating repeatedly with a care-dependent person at extremely inconvenient hours. I have had conversations with folks at the Attorney General's office, and they have assured me that they understand that within the context of the kind of work you all do, it is extremely appropriate to continue to wake people up for their medications if they're scheduled to have them. Also, to turn them every 2 hours if they're scheduled to be on a Q2-hour repositioning. So this one reads pretty weird in our context, but I don't think it's going to be applied very often. The final crime here for abuse would be stalking. Hard to envision stalking in the context of skilled nursing, assisted living, or personal care home setting. But those are the new crimes of abuse of care-dependent persons. Penalties for criminal abuse are different than they are for criminal neglect. We're looking at a first-degree misdemeanor for criminal abuse and a third-degree felony if the person is convicted of stalking. So that's the general elements of the criminal abuse and neglect of a care-dependent person. Have not gone through to give you the definition of care-dependent persons because a care-dependent person includes all of your residents. I mean, just take that as a given. Take it as a given that it now applies to all of your employees, including, I'll give you an example of how the law has changed in relation to caretakers and people who can be charged. Initially, the law required we'll call them the perpetrator, to be someone who is directly involved in the giving of care. And that is no longer a requirement. So, for example, if your maintenance director repeatedly fails to adjust temperatures or fails to check whether your fire alarms are working or your sprinkler systems are working, and that results in some sort of harm or potential for harm, for an immediate jeopardy citation, for example, the Attorney General and or the District Attorney can now charge the maintenance person, even though they're not directly involved in the care delivery. They can now be charged for criminal neglect if it rises to the level of reckless endangerment or above. Keep in mind as well that these are criminal statutes, which means that in all cases, the prosecutors have to prove what's called in the law mens rea, or intent. So the prosecutors can't just look at a bad outcome and say, oh, this bad outcome happened, and now we're going to charge someone. They have to prove some level of intent. But if you go back to previous slides and look at the definition, you have to have an intent or some level of recklessness to be convicted. So having talked about that sort of generically, let's look on at the reporting requirements because these are significant. The Department of Aging, Department of Health, and Department of Human Services have a mandatory obligation to report to local law enforcement or to the Office of Attorney General if, in the course of conducting a regulatory or investigative responsibility, such as a survey or inspection, that they have a reasonable cause to believe that a caretaker has engaged in conduct that violates this law. And I want to pause here because for those of you who've been around a while, if you recall back to 2016, there was a number of scathing articles on Penn Live called Failing the Frail, where the reporter Daniel Simmons Ritchie went through Department of Health surveys and identified cases that the reporter believed should have been treated more seriously. And that was sort of the gist of his article. And that resulted in a number of actions taken by all sorts of people. One of the direct causes or the direct outcomes of that article was a referral of all 43 cases to the Attorney General's office for further investigation. The Attorney General opened up approximately 20 cases out of those 43, and some of those were old. I mean, some of them were 3 years old, but they still opened up investigations. There were several very in-depth investigations, and there has been at least one plea agreement coming out of those investigations. So that's part of what happens when there's bad press, okay? For those of you who live in the Harrisburg general area where you have get the Harrisburg Patriot News, or any of you who can go online to Penn Live, Daniel Simmons Ritchie last week started another series of articles called Still Failing the Frail. Included in that series of articles is the fact that the Auditor General, Eugene D. Pasquale, has decided that he is going to re-audit the Pennsylvania Department of Health to see whether or not the Department of Health is appropriately investigating allegations of abuse and neglect, as well as other adverse outcomes. Additionally, Senators Toomey and Casey were given copies of these reports, and they are demanding further information. So there's an article in the paper and online about the senators' interest. Now, I'm a firm believer in Reagan trickle-down economics when it comes to nursing homes, and this is not good news for us. Right before this webinar, I called over to the Attorney General's office because they know I'm giving this presentation. And I said, so, could you just tell me the Penn Live articles, is that going to have any impact on what your agency is doing right now on the elder abuse investigations? And what I was told is that anytime there is press of this nature, it is considered to be credible information. And credible information of this type is considered a referral, which means it's something that they will be looking at. So I would suggest to all of you that the webinar is very timely, and my suggestions as we go through are things you should take to heart, because I don't think our environment is getting any better right now, and I think we're in for a bumpy time. Additionally, there was coverage, as you may know, in the Washington Post that has been picked up as well in the Morning Call in Allentown, as well as Penn Live. So if you haven't read these articles, I wouldn't read them on a full stomach. They're very slanted, biased, but from the prosecutorial perspective, they raise questions that we know the prosecutors are looking at. We now know that Congress is involved, and that's never a good thing. And we know the Auditor General is involved, and he's going to be looking at what the Department of Health is doing. So while I had thought that we were in a good period and that the pendulum had maybe come back to normal, I think we're in for a really rough time moving forward. So just keep that in mind, and we include here Department of Human Services for those of you on the personal care and assisted living side to know that there are going to be mandatory reports. And I fully expect that one of the things that the Auditor General is going to be looking at is whether the Department of Health has been making appropriate referrals for suspected abuse and neglect to the Attorney General's office. So now let's turn to how the abuse and neglect impacts and intersects with the requirements of participation in the State Operations Manual. First question is, to who do the abuse regulations apply? Now we're back into DOH land, Department of Health land, not the criminal statute. So on the criminal statute, we talk about caretakers. On the State Operations Manual and the ROPs, note that CMS has expanded the definition of staff under Ftags 600 to include employees, the medical director, consultants, contractors, volunteers, caregivers who provide care and services to residents on behalf of the facility, students in your nurse aid training programs, and students from affiliated academic institutions, including therapy, social service, and activity programs. So we're talking about a much larger and expanded definition of employees and staff. Particularly of concern to me is how we're reaching into your consultants, contractors, and volunteers. This next slide I'm not going to walk through, but I have given you here, and you can go back into the State Operations Manual to find all of the Ftags that touch on freedom from abuse, neglect, and exploitation. So let's spend a minute talking about the federal definition of abuse under the regulations. Again, this is different from abuse under Act 53. But there are some similarities here, right? We've got the willful infliction. So we've got willfulness, injury, unreasonable confinement, intimidation, or punishment with resulting physical harm, pain, or mental anguish. Abuse includes deprivation by an individual, including a caretaker, of goods or services that are necessary to attain or maintain physical, mental, and psychosocial well-being. Instances of abuse, irrespective of any mental or physical condition of the resident, are presumed to cause physical harm, pain, or mental anguish. This includes verbal abuse, sexual abuse, physical abuse, and mental abuse, including abuse facilitated or enabled through the use of technology. And that's what we were talking about a little while ago in terms of the postings of pictures and other use of Facebook, Instagram, or anything that could be presumed to be humiliating to a patient or resident. Now, the next slide we've talked about before, but it bears repeating because this is from the State Operations Manual, and this is a quote directly from CMS, and I'm going to just take a second to read it to you, just to drive home CMS's firm position. So this is from State Operations Manual. It has been reported that some facilities have identified that they are in compliance with F600 because they could not foresee that abuse would occur, and they have, quote, done everything to prevent abuse, such as conducted screening of potential employees, assessed residents for behavioral symptoms, monitored visitors, provided training on abuse prevention, suspended or terminated employment of the perpetrator, developed and implemented policies and procedures to prohibit abuse, and met reporting requirements. However, this interpretation would not be consistent with the regulation, which states that the resident has the right to be free from verbal, sexual, physical, and mental abuse. This is what we call a strict liability standard, which means if there is an adverse outcome that is considered to be abuse on the licensure and certification side, you will be presumed to have committed abuse, and you're going to get it tagged under F600. However, we look at the difference between F600 and criminal abuse and criminal neglect. And what I would suggest to you here is the defense against a criminal charge is laid out right here. If you could show all of these elements, right? You've conducted screening of potential employees. You've assessed residents for behavioral symptoms. You've monitored visitors. You've provided training. You've suspended or terminated employment of perpetrators. You've developed and implemented policies and procedures to prevent abuse, and you've met your reporting requirements. There's no way that a prosecutor could show intent to commit abuse and neglect. Intent is not an element, however, in F600, notwithstanding, and we go back to this, the willful infliction of injury, unreasonable confinement, intimidation, or punishment with resulting physical harm, pain, or mental anguish. So you look at the definition and you'd say to me, geez, Paula, that looks like we have to have some sort of intent to commit abuse or be charged with abuse under the ROPs. But the interpretation is no, we're not going, when we're looking at the facility side as to whether or not we're going to charge or we're going to tag the facility with an F600. But if you're doing training and trying to document, I would bullet point each one of these elements and should be able to show that you have done all of them. Under the ROPs, you have to screen volunteers now, and your policies have to address how this pre-screening occurs, not just for volunteers, but also for prospective consultants and contractors. And you've got to require the same scrutiny before you let them in your facility, whether you screen them or a third-party agency or academic institution screens them. And you have to maintain documentation of the screening. Now, I draw your attention to F943 for volunteer abuse training, because your training has to include these elements: activities that constitute abuse, neglect, exploitation, and misappropriation of resident property, procedures for reporting incidents of abuse, neglect, etc., dementia management and resident abuse prevention. I want to stop here, and if you're taking notes, this is a point to write this down. Do not rely on training for abuse and neglect that is provided by your staffing agencies, because we are seeing citations where the staffing agency has provided limited training but does not address the facility-specific procedures for reporting incidents. So even if you're going to say, well, our external vendors are doing this training, I would have a PowerPoint, a short, or whatever your policy and procedure is with respect to abuse and neglect. Have a handout that your volunteers, consultants, contractors, and agency staff can sign, so that you have documentation that not only were they trained externally, but they were trained on your facility-specific policies and procedures. The department has been very strong on this, and we don't have time to go into all the reasons why, but just know that this is an area that the Attorney General, as well as the Auditor, the Federal Office of Inspector General, the OIG, and Department of Justice are taking very seriously. So again, think of the trickle down and just make sure we've documented what we're doing here. I want to spend a few minutes now talking about the Elder Justice Act, which has been incorporated by reference and specifically into the requirements of participation. And you may recall that the Elder Justice Act requires covered individuals to make timely reports when they have a reasonable suspicion to believe that a crime has occurred, and we'll talk about that in a minute. If a covered individual does not report timely, they are subject to CMPs of up to $200,000, possible exclusion from participation in the federal health care programs, and if their failure to have reported the reasonable suspicion that a crime has occurred results in harm or makes the harm worse or causes another individual to have been harmed, the civil money penalty can go up to $300,000. The Office of Inspector General did a review and found out that even though there is this authority to impose civil money penalties for failure to report, no one has been fined yet. And the OIG has been very critical of CMS, and CMS is now being very critical of all of the state survey agencies for not looking to see whether or not there's been delayed reporting. We're going to talk about that in a minute. Just so that you know, CMS hasn't quite figured out how they're going to find people, individuals with whom they may not have a relationship, like a nurse aide or an LPN. And we are expecting to see proposed regulations about how this civil money penalty is going to be implemented and enforced. Crucial for all of you on the phone is to know that there are penalties if you retaliate against anyone for reporting. Now, the other piece I want you to keep in mind is that if you do make an what I call an Elder Justice Act report, which is that reporting of reasonable suspicion of a crime, you're going to have to call local law enforcement. And obviously, if you call local law enforcement, they're going to keep that on their blotter. And on slow news days, a reporter could come in and look at the police blotter and see that something has been reported out of your facility and do a follow-up. So I would urge all of you, if you haven't done it already, to develop a media response for all crisis situations. And I would consider almost any call that you're placing to the police, unless it's for minor theft, to have the potential to be a media crisis. You want to identify and train your staff about internal procedures for crisis management, including press statements and who's able to talk to the press. You should also, in connection with this, develop a response and training for your staff about how to respond to investigators, which in and of itself is a whole nother series of potential trainings. So if we've done a lot already with phase 1 and phase 2 of the ROPs, but there are specific pieces in phase 3 that also touch on abuse, neglect, and exploitation. 483.12 B4 requires there to be coordination with your QAPI plan that touches on what you are doing to keep your residents free from abuse, neglect, and exploitation. Also, 483.70 D3 under administration talks about your governing body being responsible for your QAPI program, and that the governing body has to have responsibility and accountability for QAPI. I would, if you haven't already done this, get it on your board's agenda or your governing body's agenda before November 28, 2019. So there's some resolution or some written documentation that you can present to the surveyors when they come in to see whether or not you're compliant with these two aspects. Finally, when we're talking about phase 3 of the ROPs, there's a training requirement that comes into effect under 483.95. One with respect to effective communications for direct care personnel, training on resident rights and facility responsibilities, and including a definition in that training about exploitation, which is taking advantage of a resident for personal gain through manipulation, intimidation, threats, or coercion. Now, I want to compare the abuse reporting guidelines. Okay, this does not directly implicate Act 53, which we talked about at the beginning. As a facility, as individuals, you don't have obligations of reporting under Act 53. However, Act 53 is going to inform what you have to report under the requirements of participation. So, if we look at Ftags 608, which I call the Elder Justice Act, it's implementing 42 CFR 483.12 B5, that's the regulation, and Section 1150B of the Social Security Act, right? So, what do we have to report? Any reasonable suspicion of a crime against a resident of a long-term care facility. This does not, and I underline not, apply to people who are in your personal care, assisted living, or independent living. This only protects nursing home residents. Covered individuals are the owner, operator, employee, manager, agent, or contractor of the facility. So it's important to make sure your contractors and agents know about their obligation because they are a covered entity under this Elder Justice Act provision. So what do they have to report? Any reasonable suspicion of a crime to the state agency and one or more local law enforcement entities. There's a whole list of who that could be depending on what the issue is. When do you have to report it? If it's a crime that's resulted in serious bodily injury immediately but not later than 2 hours after forming the suspicion that a crime has been committed, or if there's no serious bodily injury, not later than 24 hours. So how does this correlate with Act 53? you have to go back and look at the definitions of what is now considered to be a crime under Act 53, because the things that you have to report under F608 have expanded, if that makes sense to all of you. I can't see because I can't see your faces to know if I need to explain this any further. But basically, you need to look at Act 53, reckless endangerment, abuse, all of those are going to be reported now as crimes. If there's serious bodily injury, not later than 2 hours after forming the suspicion. If there's no serious bodily injury, and that would be a lot of those reckless endangerment cases, not later than 24 hours. So that's the correlation there between Act 53 and your reporting obligations. But then you look at F609, which is our generic reporting of abuse, neglect, exploitation, and theft, injuries of unknown origin, and misappropriation. So you have to report all allegations, and I say all alleged violations. So don't wait to do your investigation and then say, well, it's unsubstantiated, therefore I don't have any reporting obligation. Any time there is an allegation of abuse, neglect, exploitation, mistreatment, including injuries of unknown source, and misappropriation, you have to make a report. So you have to do your reporting and also report the results of your investigation. This is not an individual reporting obligation under F609. This is the facility's obligation. So note again that difference between the Elder Justice Act, which is individual, versus your generic reporting, which is the facility obligation. Employees should be reporting to the facility administrator and to other officials in accordance with state law, including to the state agency, which would be the Department of Health, and Adult Protective Services, which in Pennsylvania would certainly apply. If the person is older adult, you obviously are making that report to the Department of Aging under the Older Adult Protective Services Act, or to Liberty under the Adult Protective Services Act, but we're covered coming and going. Now, when are these allegations supposed to be reported? All investigations, all violations alleged have to be reported immediately if the alleged violation, immediately but not later than 2 hours if the alleged violation involves abuse. So every allegation of abuse, whether it's substantiated or not, you've got 2 hours to report. Additionally, alleged violations that result in serious bodily injury have to be reported within 2 hours under F609. You've got 24 hours if the alleged violation does not involve abuse and or does not result in serious bodily injury. So you've got to break that out. Bottom line is all allegations of abuse have to be reported to the Department of Health and the appropriate protective services agency within 2 hours. Serious bodily injury, again, 2 hours. 24 hours if it's not serious bodily injury or if it's an allegation of neglect, for instance. But then you have to go back and say, okay, I've got an allegation of abuse. Is it criminal abuse? And that shoots you back to Act 53 to determine if what is being alleged falls into that bucket of criminal abuse, which would require reporting to local law enforcement. So not all alleged abuse is criminal abuse. Just keep that in mind as we go, as you go back to your buildings to try and figure out how you're implementing all of this. This lovely chart just shows you some of the crosswalks between F600 and Act 53. So you've got those crosswalks there that will give you some idea of some of the things. Corporal punishment, obviously, we would know would be abuse. Involuntary seclusion, involuntary restraint is covered as well. Staff retaliation, having an unsympathetic attitude could potentially be considered abuse under the new definitions. Chronic staffing problems could also be criminal abuse, depending on the outcomes if you look at the definitions. Physical abuse, deprivation of goods and services, mental and verbal abuse, and sexual harassment. Both the State Operations Manual, the ROP, and Act 53 have what I call a safe harbor or an exception, which is, you're conforming with the resident's wishes or a DNR or some other advance directive that says that, the resident wants this outcome. So you want to make sure we're following those very carefully as well. CMS is starting to make tools available, and this is one tool that you may want to look at as you're considering how you're doing your expanded training. This is their hand-in-hand series, and there is a segment on preventing and responding to abuse. I think it's great if you can use the modules from CMS and have documentation that that's part of your training, because obviously there can be no question that that's an approved training methodology there. So what are some abuse and neglect strategies? I think you need to sit down with your teams and consider what is reportable abuse and neglect, and do your best to get rid of the misconception that you only have to report abuse if it's substantiated. The regulations now require reporting of abuse of any allegation. Consider as well, if you're using only online training, how valuable is that? How effective is it? You may want to revisit that, because I think at some point, as the survey process gets a little bit more advanced, we're going to start seeing surveyors looking and asking staff very specific questions about your policies and procedures. We've already talked about training for media, inquiries, and I really would encourage you to consider training on what rights you and your staff have when an investigator knocks. And finally, I want to leave you with a to-do list to make it easy for you to go back to your facilities and figure out just how you start getting a handle on this. First is to review and update your existing abuse and neglect policies and procedures to incorporate Act 53. And then you're going to have to update your training materials and then train them. Look at your QAPI plan for inclusion of abuse, neglect, exploitation issues. Make sure that's in there. Make sure you've got some documentation that the governing body is in charge of QAPI. Retrain your staff. And remember, that definition of staff is much more inclusive than it used to be. So consider how it is that you're going to document the training for volunteers, contractors, vendors, consultants. And then consider how you're documenting that training. But it's no longer going to be sufficient to rely on the fact that, you're getting staff from the Paula Staffing Agency, and I'm going to tell you I've trained my staff on abuse and neglect, because the surveyors really want to see that it's specific to each of your facilities. And this next one, monitor for further guidance from the Department of Health. PHCA is doing this for you, but you may also want to keep an eye on it. The Department of Health is aware that Act 53 has come out, and they're trying to figure out what guidance they're going to be issuing about how this is going to be implemented. Also, you should know, if you don't already, that the Department of Health is on track to issue proposed regs either by the end of December or mid-January. And when you read the Penn Live articles that I've talked about earlier, you will see reference to this as well. I fully expect that we're going to see language in the proposed regulations that talk not just about staffing, but also abuse and neglect. And PHCA is right on top of those issues. The final thing to think about is, whether you should be talking to your local law enforcement and saying, okay, here's new Act 53. I know some of you did this when the Elder Justice Act came out and said, here's what we're required to report. What do you want? How do you want this process done? And in light too of this final thought on the Elder Justice Act, I'd make sure that you're in compliance with getting your mailings out and having your posters up if they've come down, because we're seeing facilities getting cited for that as well. And with that, if we have any time left for questions, I'm not sure that we do. I'm showing that I'm pretty close to 11, but I'm happy to answer questions after the webinar as well. And Wendy, I'm going to turn it over to you now. Thank you very much.
Great. Paula, thank you so much for sharing this really important information today. We really appreciate your time, and there's a lot of things to consider here. So we really appreciate the timeliness of the webinar and the information that you provided today. At this time, we'll open up the question and answer portion. If you do have any questions, if you could type them in your question pane, we'll just spend a couple of minutes on it. We are getting close to the 11 o'clock hour, and we want to get everybody back to your day. So if you do have any questions, and if we can't get to questions, know that we will have Paula answer them, and we'll put a document out to everyone by the end of the week. So we do have another webinar coming up on mandatory abuse reporting on December 6th. So if you haven't signed up for it, and we're working on our 2019 webinar schedule, so keep an eye out for that information as well. Paula, I think you did a really thorough job. I'm not seeing any questions, so you must have covered everything.
Thanks. Like I said, if there are other questions, or anybody wants a copy of the Act 53 or links to the articles I talked about, shoot us an email and we'll get them to you.
Great. We'll be putting Paula's information in the follow-up email that I send to everyone. That information will go out, and Paula's contact information will be there. Feel free to reach out to her directly, and know that we here at PHCA are your resource as well. So again, don't forget to complete the survey that I'll email to you later today, along with the recording of today's webinar. Feel free to share that information with folks, in your facility, other peers. It is a recording that is made available on our website, so anyone can listen to that afterwards. Again, thanks to Paula for your time today and presenting on this topic, and everybody have a great remainder to your day.
Thank you.